Okay, good afternoon, friends. At the outset, let me congratulate each one of you for going to participate in the All India Opinion Writing Competition. My best wishes to all of you. Before you proceed, I thought let me give you some kind of a guidance in the opinion writing and what is the objective of these opinions and all those things. You all might be knowing by now that the stakeholders means any company or a firm or a trust or an individual, any entity, they approach the experts normally. It may be a chartered accountant, maybe a cost accountant, company secretary, or legal person. So we approach for an opinion wherever there is an scope for interpretation in the section. That means whenever we are going to take a decision which is subject to the Companies Act or listing regulations or any other security laws, if in that particular section what you are going to comply with, if there is a scope for interpretation is there. So that point of time, what happens is you have to take a call. Similarly, there may be some situations where there is an ambiguity in the section. That you know it very clearly, there is an ambiguity. That point of time also you have to take a call while implementing that section. Sometimes it may so also happen that the act is silent on certain things. Even at that point of time, you will be again, the person who is complying with that section has to take the call. So there are three stages where while you are implementing the section, you have to have an opinion of an expert. Primarily, the opinion when you are complying with, and tomorrow if the regulatory authority or the judiciary is not accepting your compliance the way you have interpreted the section, the opinion may not come to your rescue and absolve you from the non-compliance. However, once you take an opinion and you have taken the decision based on such opinion, and in that opinion the interpretation of the section has been given, if the regulatory authority or the judiciary got convinced based on the opinion, they may allow your case. This is primarily the objective of the opinion what for we approach. Now the question is, you are the expert and you are in the position to give the opinion, so you have to write the opinion. Before you go for giving your opinion, what you have to do is you have to have a case for opinion from your client. You should never give an opinion based on the verbal request. The reason being, as we all know that there are some communication barriers are there. That means we all learnt while we were studying for company secretaryship or chartered accountancy, the barriers of communication. One of the major barriers for communication is that we always think that whatever we are communicating is what we want to exactly communicate. But we might not be communicating even 50% of what we want to communicate. Second, we always assume or presume that the other person with whom we are communicating, he is understanding our communication the way we are communicating. But in fact, it may so happen he is not even understanding 50% of what we are communicating to him. So in this process, what is happening is hardly 25 to 30% of communication, what we want to communicate, is ultimately reaching. This is the main barriers of communication. Keeping this in view, you should never give an opinion based on the verbal verbal request. So what you have to do is always you have to ask for a case for opinion. In fact, several times it may so happen whenever we are going to a very renowned lawyer or sometimes retired Supreme Court or High Court judges, at point of time even the case for opinion also is drafted by a legal expert himself. The reason being that when we go to such a kind of personality to obtain his opinion, the case for opinion is also to be crystal clear. Then that once in the case for opinion when you are drafting, what are all the contents of the case for opinion. In the case for opinion, the person, whoever is drafting the case for opinion, in case you are drafting, you have to keep these things in mind. Or if you are getting that, you have to ensure that in the case for opinion, all these things what I am telling now are already there. First, what are the issues involved on which your opinion is being sought? Second, when you are examining these issues for implementation or to take a decision, which are the acts which are going to applicable to you? That means it may be Companies Act, it may be listing regulations, it may be SEBI regulations, LODR, takeover, or your PIT regulations, so on and so forth. So which are the regulations and which are the sections exactly are going to apply there for the issues involved? And based on that, your client has to give what is his opinion, how he is interpreting that particular sections or provisions of the acts which are concerned with the issues involved. Finally, what he has to do is, in case he has any case laws with him, he has to furnish that also. Based on these case laws, based on these regulations, based on these provisions, what opinion he is forming himself, that also he has to give in the case for opinion. Finally, in the concluding, he has to give you the points on which your opinion is sought. 1, 2, 3, 4, 5, like that he has to give it. Once you got the case for opinion in your hand, you have to understand that thoroughly. After that, you may have a conference with your client wherein you need to understand it, or wherever the disconnect is there, that is to be connected, and then you have to start your homework. Your homework means you have to have a good research work. You have to understand the issues involved very clearly. After that, what are the legal provisions applicable to those issues while you are dealing with? Then, what the interpretation was taken by your client, whether you agree with him or you not agree with him, or over and above that, in which way you are interpreting the sections. And then you have to also examine the rules and regulations, the circulars, notifications, amendments, removal of difficulty orders, whatever are there, you have to examine all those entire paraphernalia of the issues, the legal provisions. In addition to that, you have to also examine the case laws, which will be of supportive to you. Normally, whenever you write an opinion, to a large extent, your opinion is to be always supported, not only of your interpretation, but also some decided case laws are there of the state, or the high courts or the Supreme Court. It will be of great help. So you need to also have a good amount of research as far as the case laws are concerned, which are going to give you support to your interpretation or your opinion. After this, what you have to do is you have to draft an opinion, and then you have to give the draft opinion to your client. You can ask him to examine that, whether he is on the same page with you, or if he has certain other issues he wants to tell you. If he agrees that the draft opinion, whatever you have given, he is in concurrence with that, then you can finalize and formalize that opinion. Alternately, if he is not in agreement, or if he has certain more to say further, you have to hear to him and you have to work upon that further. Once your client is in concurrence with you, you have to now come to your formal opinion. While you are writing the formal opinion, you have to always remember that the opinion should be crystal clear, it should be crisp, and it should be drafted properly. You have to give paragraphs, you have to give that reference numbers, and a person who reads, it should be in a self-explanatory mode. The opinion should be always be self-explanatory. It should not give any opportunity for anyone to refer to any books. That means whatever the legal provisions are there, whatever the case laws references are there, everything you have to furnish in your opinion itself. There should not be any kind of ambiguity to be left in your opinion. There should not be any ifs and buts in your opinion. There should not be any problem subject to this. You are giving your opinion like this and all. It should not be there. And finally, you have to say that whatever the case for opinion you have received, Based on that, you have to draft your opinion, and finally, you have to give whatever the points on which your opinion is sought. You have to give your opinion. Friends, that I'm sure this guidance, whatever I have given to you, will certainly help to you, and not only for this competition as well as for the your future professional requirements. One thing as a senior member of this profession of company secretaries, I want to tell you is that we are fully equipped with knowledge of giving opinions as far as the cases pertaining to especially to Companies Act and the security laws are concerned. But we all know that most of the times the legal opinion means the stakeholders go to the legal professionals only, that means only the advocates. One of the reasons for that is that we are still not matured enough to give opinions, or we are not able to write the opinions in the way they are to be written, or we are not able to, I mean, our opinions are not still being accepted in either by the regulatory authorities or by the judiciary. We need to have a good amount of introspection for this. We have to work hard and we have to establish ourselves. We have the knowledge. Only thing is we need to be mature enough, and we have to get the we have to get the excel. We have to excel in the way how the opinions are to be given. I'm very happy that CCGRT of ICSI has initiated this All India Opinion Writing competition. And I'm sure that when you're participating in this competition, you will be working hard, and you will be putting your soul into the case for opinion what has been given to you. So because everyone, whenever we are participating in a competition, we want to win the whatever that prize or whatever it is. I'm sure that you all are working very hard towards this. I wish you all the very best once again, and God bless you all. Thank you very much.